Welcome back to One Stop Law. In our previous lecture, we have learnt about the meaning of fraud and the various methods by which fraud is committed in a contract. The specific 5 methods. I have also discussed some case laws with you and given you examples, by which fraud may be committed. In this lecture, we come to the next part of section 17, which deals with effect of silence on fraud. Like there is a specific question or part that whether silence amounts to fraud. You get. So as you can see, there is an explanation in section 17 which says mere silence as to facts likely to affect the willingness of a person to enter into a contract is not fraud. So we learn that mere silence is not fraud unless the circumstances of the case are such that being regard had to them, it is the duty of the person keeping silence to speak, or unless the silence in itself is equivalent to speech. So what it tries to say is that mere silence does not amount to fraud unless there is a duty to speak. So silence does not amount to fraud. So suppose there is actually a famous maxim, if you know, that a caveat emptor. There is a legal maxim which talks about caveat emptor, which means buyer beware. So when we go to a shop to buy a thing, we ourselves must be aware. Okay, it is not the duty of the shopkeeper to disclose each and every defects in his belong in the goods he is selling. Of course, if that is very material to very much the defect which his goods have is material to its use, like suppose I went to the shop and the to buy a pen and the pen is not working, then it is his fault, no doubt about that. So there are two conditions also given, where there is a duty to speak or where silence amounts to speak. But the first, the essence of this explanation is that mere silence, only silence, that the shopkeeper does not tell the defects on his own, does not amount to speak, does not amount to fraud, because there is always a duty on the buyers also to inquire about it. You can see the illustration. A sells by auction to B a horse which A knows to be unsound. So A has put up an auction of a horse where A himself knows that the horse is unsound. A says nothing to B about the horse's unsoundness. This is not fraud by A, because B never inquired about the horse's soundness. Okay, B never asked A that whether is your horse sound, something like that. So where B, the buyer, never inquired about the defect of the goods put up to sell by the seller, the vendor here, A, it does not amount to fraud if A has not spoken about the unsoundness, because A had no duty to speak. Mere silence does not amount to fraud. A's silence, mere silence here, does not amount to fraud. However, there are two provisos which I will do in the next slide, where I will discuss what are the exceptions to it. So the main rule is that mere silence does not amount to fraud. Then there is unless there is a duty to speak or silence is equivalent to speech. So here you can see there are 4 exceptions to the rule that mere silence does not amount to speak. First is where there arises a duty to speak. So if there is a duty on the person to speak, then also if he remains silent, then it is a clear case of fraud. You can see an illustration is given. B is A's daughter, and B here in this case has just come up of age. That is, B has just become major, or is a very novice person in this case. So here the intention between the parties would make it A's duty to tell if the horse is sound or if the horse is unsound. So this is basically a continuation of the illustration which we did in our previous slide. That in the previous slide what we saw, A sold an unsound horse to B, and where B had never inquired about the soundness of the horse to A, and therefore it was not a case of fraud on part of A. But in the latter case, A knows that here the buyer has just come of age, that is B's daughter. Okay, in this case is just a person who has who has nothing, who is not so matured. So here A already has a duty to speak on his own, because he knows in this case the person to whom he is selling the horse is not matured enough. So the daughter is not matured enough, so to ask A whether the horse is sound or whether the horse is of proper good health or not. So it is in this case when A is selling his horse to an underaged person, to not an underaged person, just a person who has come to the age of majority, say 18, who is not so matured. So here A has a duty to speak, even if B's daughter does not ask about the soundness. So where he has a duty to speak, he remains silent, then it amounts to fraud. I will give you another example, considering just the previous illustration. We learned that A had put up his horse for auction for auction, uh, and B bought that horse. Now before making the final payment, maybe it was through bids, auctions are always done through bids, and B won the bid, okay, and then before making the final payment, B asks A that is your horse sound. Now in this case, when B has already inquired about the soundness of the horse, here A has a duty to speak. Here also if A remains silent, then definitely it's a case of fraud, because now A cannot remain silent, because B has already exercised his caveat emptor, his awareness. He asked about the soundness, so here A has a duty to speak. So here also if A remained silent, then it is a case of fraud by A. The next scenario is where silence is deceptive. So where it is said that I will infer something from your silence, okay, and then also the person remains quiet. So you see the illustration, B says to A, that is the buyer, B is the buyer, he says to A that if you do not deny, I shall assume that the horse is sound. Here also A says nothing, and this is in this case A's silence is equivalent to speech, and A is said to commit a fraud. Why? In this illustration also, this is the same continuation of the same illustration. In that auction only, after winning the bid, B went to A and asked A that if you do not reply to me or if you do not deny, I will presume the horse to be sound. Now A knows that the horse is unsound, and in this case what B has said that if you do not reply to me, then I will presume that the horse is sound. Okay, that means now if A remains silent, we will presume that the horse is sound. A is saying that the horse is sound. So here A's silence is equivalent to speech, because B has said if you do not deny, I will presume the horse is sound. So to say the truth, A has to speak. A cannot remain silent. So in this case, A's silence is equivalent to speech. So if in this case he doesn't speak up, A's silence will amount to fraud. The third case is change of circumstances. So it might happen, when the contract was actually formulated, then some situation was there. Now in the meantime, the situation has changed. So it may sometimes happen that an assertion when made may be true. However, on account of change in circumstances, it may become false at the time when it is actuated upon by other party. So when A had promised to sell the horse to B, the horse was sound. And B had also inquired about it that the horse is sound. In the meantime, selling and buying takes up some time. In say it was to be actuated after a week, and within that week the horse went unsound. So in this case, now again it is A's duty to speak about the unsoundness, because here circumstances has changed within a week. At the time when the sale was the initial deal was finalized, the horse was sound and no one was wrong. A was also not wrong in saying the horse was sound, neither was B wrong in accepting it, because B had inquired about its soundness. Now in the meantime, in between the 1 week or 10 days from the day of finalizing the deal and actually selling the horse by A to B, the horse has gone unsound. So there is a change in circumstances, and it is now the duty of A to tell about this unsoundness to B, otherwise it will be a case of fraud. And the last is half truths. Whenever a person discloses something, whether out of his duty to speak or not, he must disclose information in toto. A half truth is a lie. So we just learned that mere silence does not amount to speak unless there is a duty to speak. Okay, so when I am not asked to tell about anything, I am not bound to tell anything. But suppose I on my own try to disclose something, then I am duty bound to disclose the whole thing and not half of it. So if I tell half of the truth on my own and I keep secret the other half, I conceal the other half, then also it's a fraud. Why? Half truth is as good as a lie. Okay, now coming to the last segment of fraud, that is effect of fraud on a contract or consequences of a fraud. So we all know that when someone's consent to a contract is obtained by fraud, the contract will be voidable. Voidable means the party whose consent was so obtained can avoid the contract by going to the court and declare it void. So this is given actually under section 19 para 1. He can rescind the contract. Okay, the first effect. Okay, rescind means he can get the contract declared void by going to the court. That is how a voidable contract is. The second consequence, the second right this person has, okay, on whom the fraud was committed, that he can insist on the performance of the contract on the condition that he shall be put in the position in which he would have been if the representation have been made true. So suppose, you know, I gave you just example of this horse. Okay, let us continue with this example. So here we wanted to get a horse from A, and suppose B had inquired about the unsoundness, and A, knowingly that the horse was unsound, has told B that, you know, the horse is sound and you take it. So later on B came to know that the horse is unsound. So in this case, what he can do, the first remedy is he can avoid the contract. He can, you know, set aside the contract by going to the court. That is the option of voidable contract. The second option B has is he can insist A to give him a sound horse. Okay, that is specific performance. The contract which was agreed between them, A and B, that is A to sell a sound horse to B. So B can insist A to do what he agreed to do actually, what he was supposed to do actually, that is sell him a sound horse. And the last is, of course, the other party, the person can sue for damages because he had to go through all these harassments. He was, you know, he was cheated, fraud was committed on him. So always he has the right to sue the party who has committed such fraud to for damages, for compensation in the court. So this is all about the effect of fraud on a contract. In our next lecture, we will do the factor of misrepresentation. Thank you all.